This is case number 21-165-707. This is Jacqueline Spearman versus Foster Park Apartments. The matters before the court set on for a pretrial conference on today's date. Your appearance for the plaintiff in this matter, please. All right, do I have Jacqueline Spearman on the Zoom?
Yes, sir. I'm here. Good morning, Your Honor.
All right, good morning, Ms. Spearman. For the defendant across the park, please.
Good morning, Your Honor. Brian Butchart, P66250. I represent the defendant.
All right, thank you. Thank you, Mr. Butchart. I extended discovery in this matter through today's date, and I think I directed, well, I guess they're already been received in this matter. Has discovery now been completed regarding this matter, counsel?
Judge, I did receive a number of discovery responses from Ms. Spearman. I think it was last week. I think that there were still some items that maybe she was planning to follow up and provide, although I'm not certain of that. But yes, it's been substantially, I think, completed. I don't know how much more information Ms. Spearman might be planning to provide, but yeah, that's where we're at.
All right, very well. Ms. Spearman, if you requested any information from across the park, have you gotten any information that you requested from them, ma'am?
I have not requested any information from them, Your Honor.
All right, thank you, ma'am. All right, so counsel, have you had an opportunity to talk with Ms. Spearman relative to whether or not there is a way to resolve this? The complaint in this matter seems to sound in slander, harassment, false accusation of violence, falsely eviction, false lease agreement, property damage, endangering plaintiff's safety, using retaliatory practices, unmet property repairs, mental anguish. Frankly, some of those things would not really state a cause of action before this court. But have the parties at all talked about this to see whether or not there is something to this that the parties can discuss and find a way forward?
Judge, we did mediate with the, I think it was the Wayne County Mediation Center. I'm not exactly sure which agency it was with, but we did mediate. Unfortunately, it was not productive. My client's position is that that the case completely lacks any merit whatsoever, and so obviously my bargaining position is I don't have a lot of flexibility, and so that's kind of where we're at on my end.
All right, very well. So, do you have any idea how long this was a rental agreement or something, correct?
There was a landlord-tenant relationship. The parties were previously in court on a landlord-tenant action, did sign a consent agreement in which Ms. Spearman agreed to move out. And so yes, this stems from that relationship.
All right, how long did that relationship endure, to the best of your knowledge?
Judge, I'm not sure I have an answer to that at this time.
All right, Ms. Spearman, how long was that relationship? How long were you in this back?
And it was a year, Your Honor.
Okay. All right, very well. So it looks like the parties are in impasse and that you want this matter set up for a hearing, and the court will set it for the same. Just one thing right here. And I, of course, note that there is a counterclaim in this matter as well. All right, very well. So I'm going to go ahead and set it for a trial date. My clerk's going to give you that date in just a moment. Just 1 second.
Which how far are you on it? Try them on June June 30th, you say end of June, June 30th? You have a trial that day.
June 30th, 2022. I'm setting the matter on for 11 o'clock a.m. That is the trial date in this matter.
I'm sorry, what time was that again, Your Honor?
That's going to be 11 o'clock a.m. on June 30th, 2022.
Oh, you said a trial. Wait, trial, you have another trial also.
Oh, wait a minute.
Yeah, no,
Hold on a second.
you have a trial, I thought you were, yeah, no, so you have to go in July. You got July the 6th and July you want later in July or?
No, let's do it. Okay, July the 6th. I got to change that date. July the 6th. And that's going to be 11 o'clock a.m. July 6th, 2022 at 11 o'clock a.m. And there will be a notice sent in the mail, 7/6/22 at 11 o'clock a.m.
Thank you very much, Your Honor. You and your staff have a great day and a wonderful holiday weekend.
And likewise, sir, good day to you, Ms. Spearman.
Good
See you
day,
on the
Your
6th.
Honor.
Okay, good day to
Thank you. Have a great day.
This is case number 21-167180. This is Discover Bank versus Cynthia Warren. The matter is before the court. The court having adjourned the matter, it appears the defendant was in hospital on the last occasion. I set it for review on today's date. Your appearance for the plaintiff Discover Bank.
Thank you. Good morning, Your Honor. Jennifer Dillo, P69855, appearing on behalf of the plaintiff.
All right, thank you, Ms. Dillo. And do I have Cynthia Warren, anybody representing Ms. Warren here at this time? Say something if you're here.
Yes,
All right, what's your name, ma'am?
Cynthia Warren.
All right, thank you, Ms. Warren. Good morning to you, ma'am.
Good morning.
So I saw in this case that there was a judgment that was presented to the court for entry of default judgment for in excess of $10,000. And I saw that was presented to the court on in March, but I see that there is an answer that was filed in this matter. The answer was received by the court in February 22nd, 2022. Counsel, update me on what your thoughts are regarding this matter, ma'am.
Thank you, Your Honor. Well, as of today's date, plaintiff has not received a copy of the answer, which is why the default judgment was first submitted to the court. I can see that there was an answer filed, and it looks like the court signed the default judgment on April 25th, 2022, which was the date of the last hearing. I don't see it on the Register of Actions, but my office received the entered default, which it appears was entered in error. So I would just, whatever the court wishes to do with that.
Yeah, given that, Ms. Warren and Madam Counsel, given that I have received the answer to the complaint on February 22nd, that would have prevented the submission of a entry of default. And so the court will set aside any judgment that it entered as a result of that error. And so now the matter is properly joined before the court. I would normally allow some period of discovery, that is for the right to exchange information. And so I'm going to go ahead and do that. And so over the next 60 days, the parties will have an opportunity to discover information and to share information mutually. That means that if you receive something in writing requesting information, you're required by the court rules to respond to that information, to answer questions, to answer interrogatories if they're submitted, to answer requests to admit documents if those documents are submitted as well, and to return them to the respective party. If Ms. Warren sends something to Discover Bank requesting documents, they will have to send those documents. If Discover Bank through their attorney sends a request for information from Ms. Warren, she will have to submit that information within the time that is permitted. So I'm going to set the next action date about 60 days since that date's going to be 7/22.
26.
7/26, I'm sorry, 7/26/22. And that's going to be at 9:30 a.m. July 26, 2022 at 9:30 a.m. Between that now and that time, the parties have the right to open discovery. You'll receive an order from me that allows that to occur. The parties also have the right to file a motion or any motion in front of me, whether it disposes of the case or not. If you wish to file a motion is a petition to have the court to hear something. If you wish to file a motion in front of me, you do so and set it for hearing on the same date. That is set. The only requirement is that you make sure that the other side has at least 10 days notice before the hearing of what you're requesting the court to do. That could be a motion for summary disposition. It could be a motion to dismiss, et cetera, et cetera. All you have to do is make sure the other party gets a copy of it 10 days before the hearing. And I will hear it on the 26th of July, 2022 at 9:30 a.m. All right, that is the order of the court. You receive a written document in the mail from me with the same information in the next few days. All right, thank you, counsel, and good day to you, Ms. Warren.
Thank you.
Oh, I'm sorry, Judge. I'm having connection issues. I missed out on after you said you allow for discovery, and I didn't hear anything else because I have connection problems with this
Not a
app.
problem. I'm sending you a document in the mail that's going to allow open discovery through the 26th of July. And July 26th is the next date that you have to come back.
Okay, so is there anything specific I need to be doing with the plaintiff for this?
Well, if you have over the next 60-day period, you can request any documents that you believe might be helpful to your case. If you believe that they have something in their possession that could help you with your case, you can request that, and they will have to send it to you in writing. And also, if they send information to you, and if they request information of you, or they send questions to you, anything along those lines, you have to answer it and send it back to the attorney during that 60-day period. Do you understand?
I got it. And then there was something else that you mentioned that I missed out on as far as.
I was talking about filing motions. If you wish to file something as a petition to ask the court to take certain action, that's called a motion. If you wish to file a motion, you can do so. And I gave you the hearing date already. That is the 26th of July. And
Okay.
the only requirement is if you're asking the court to grant grant a petition that you're bringing before the court, you have to make sure that the other side is put on notice of that 10 days before the hearing. So 10 days before the 26th of July, you would have to make sure that the other party knows of the motion that you're filing, asking the court to do something. Understand?
Yes, and I have one more question because I know there was something mentioned about a default order, but there was a response.
Let me stop you. The default, what you heard about that was that the default order was set aside because your answer came in before the default. So there is no default at this time.
Okay, so there is no default. Okay.
Yeah, now you're breaking up, and I can't. All right. I believe I heard you say thank you. Yeah, that's the end of the hearing. You'll receive a copy of the order in the mail in the next few days. I wish you well, Ms. Warren. Good day to you. Ms. Dole, good day to you as well, man. The court now calls case number 21-161-839. This is Coleman L. Potts versus Riverfront Towers Apartments. The matter is before the court, set on for a pretrial conference. The court did allow for a scheduling order previously regarding this matter, and I believe that this hearing is after the scheduling order, I believe. Your appearance at this time, or plaintiff, you may at this time.
Attorney Coleman Potts, we have plaintiff.
Thank you, Mr. Potts. Good morning to you, sir.
Good morning,
Put
Judge.
your P record, if you will, Mr. Potts.
78607.
Thank you, sir. For the defendant, Riverfront Towers Apartments, your appearance at this time, please.
Good morning, Your Honor. My name is Matthew Miller, P51351, here on behalf of the defendants.
Thank you, Mr. Miller, and good morning to you, sir. All right, and I noticed you said defendants, so you're talking about River Towers Apartments and National Credit Systems Incorporated, correct, sir?
No, Your Honor. I'm representing in Riverfront Towers Apartments and AMP Residential.
All right, gotcha. All right, thank you, sir. All right, so looks like I received, well, yeah, the answer's been here a long time ago. So somebody update me. Where are you with this matter?
Your Honor, we've been participating in discovery. Counsel for the defense filed a motion for leave of court for a counter complaint. I didn't see a date set for that. I know he noticed it up, but I don't know if the court ever provided a date for that. Like I said, we've been participating in discovery, probably going to need an extension on discovery, and I'm going to need to take some depths as well once I go through everything.
Your Honor, I filed two things with the court. I filed a motion to file a counter complaint back in March with a blank notice of hearing, asking the court to set it for hearing that according to the Register of Actions, you should have in your chambers. I also filed a substitution of attorney because I left my prior law firm and I'm now out on my own, that the court also has, that needs to also be entered.
I do see the substitution of attorney document, and I don't think there's any objection in that regard, and I'll sign that order at this time. Now I'm discovering somehow the petition with regard to the motion for leave to file a counter complaint. I have received that. For some reason, it made it directly into the file, and I haven't looked at it yet. Give me the Mr. Potts. You've had an opportunity to read and go over the motion for leave to file counterclaim.
I have, Your Honor.
You said you have, sir.
Yes, Your Honor.
All right. All right. So, are you ready to argue with regard to your position in that regard, sir?
I mean, it's a counter complaint that should have been filed with the answer in my opinion, but I mean, I'm objecting without argument, Your Honor, so I'll leave it to the court's discretion.
All right, and Mr. Miller, the rule that is so commonly understood by so many of us is that amendments are to be allowed when justice so requires. So,
Yeah.
do you think of is this one of those requests that fits within the justice so requires?
It most certainly does, Your Honor. The plaintiff's complaint is actually seeking declaratory relief that he should not be charged the money that we're seeking in the counter complaint. So the case makes no sense without the existence of the counter complaint. And the matter was brought before the court on March 23rd at the last pretrial. And the court directed the other attorney from my former office to file this motion. So we literally filed the motion the same day. There's no prejudice to anyone. In fact, Mr. Potts asked in his discovery request how we came up with the figure that we're seeking in our counter complaint, which we explained and answered. So most certainly this is a requisite motion that needs to be granted, and the counter complaint needs to be part of this case.
Sounds like you're saying to me it would help to join all of the issues to be heard at one time. And justice would so require. It does seem to be a reasonable request. The court will grant the motion and allow leave to file a counter complaint in this matter. That leave 21 days to do so, Mr. Miller, enough, sir?
Your Honor, frankly, the counter complaint's attached to the motion. So according to the Register of Actions, it was the ROA shows that it was actually filed on March 29th, and then it says motion in parentheses. So I'm not sure if it's been filed or I don't know what the status is, but I can submit another copy to the court if that's what needs to happen.
We would be on the same page here. I'm not sure what would have happened in terms of how it's documented. Because the court has granted the motion today, I will allow the counter complaint. So the counter complaint is allowed as of today's date.
Do you want me to submit an order, Your Honor?
Yeah, somebody's going to need to submit an order for a couple of things.
Okay, I'll submit an order granting the motion. Is that something I should fax to the second floor, or how do you want me to handle that?
I'm going to give you an email address for that in a moment. You're going to submit an order allowing the counter complaint, granting the motion, allowing the counter claim. I would like I would like to include in that proposed order that you would submit an extension of discovery, because it doesn't seem that there is any reasonable argument here that discovery needs to be extended a bit here. Say maybe 60 days or so.
And can we also include in that depths are allowed, Your Honor?
Yes. Yes, so, Mr. Miller, and that's why I was we were chopping back and forth a little bit because, if the order could be inclusive of those, items that discovery is extended for, 60 days. I'll give you a specific date, in just a moment. Actually, it's going to be the 26th of July, July 26th. And we'll set this at 9:45 a.m., July 26th, 9:45 a.m. And discovery is extended through that date. Such discovery allows for, among other things, allows for taking of depositions, if the parties wish to do so. Anything else that needs to be included in that order? I'm signing the assignment of counsel order separately. That is the substitution of counsel. But the place where you would send the order, sir, to get it done right away, would be to the following address: Latifa, LATIFAH dot Hunter is the last name, HUNTER, at 3636th districtcourt.org.
Your Honor, can I just read that back to you, please? LATITLAH. Did I mess it up?
LATIFAH dot Hunter.
Dot Hunter. Got it. LATIFAH.Hunter at 36districtcourt.org. All right, I will prepare such an order. I'll get it over to Mr. Potts for his review today. Does Your Honor need me to submit another version of the counter complaint, or is the counter complaint already in the court's file?
The common complaint is in the file, and all your order needs to say is motion, the counter complaint is accepted.
Okay.
And
then
I
how-
guess,
should
I guess the
put in-
order will, sorry, I guess the order will read that I have 21 days to answer that complaint.
Makes sense. All
I'll
right.
put that in. That's fine.
Okay.
Okay, I can do all of that. Thank you, Your Honor.
In that order, you'll get a notice of hearing from me for the next action date, but go ahead and put it in the order. The notice of hearing date is 7/26/22 at 9:30 a.m.
Got it. Wait, I thought you said 9:45. 9:30, Your Honor?
9:45.
9:45. All right, I will take care of it.
This particular Zoom number in that order as well.
Will do.
All right. All right. Good day to you.
Thank you. Thank you both. Have a great day.
Thank you, Judge. Have a good one.
I want to make sure you guys do the order the way I would do it, put everything in.
I will.
Absolutely.
Sounds good. Thank you, Judge.
Thank you.
See you soon.
Yep.
Okay. Okay.
The court now calls case number 21-166061. This is Cash LLC versus John Colsey. The matter is before the court, set on for hearing on a motion for summary disposition. Your appearance at this time for the plaintiff.
Good morning, Your Honor. Keith Sparks on behalf of the plaintiff.
John Finn, excuse me.
First of all, Mr. Sparks, if you will, your P number for the record, sir.
Oh, sorry, P77485.
All right, thank you, counsel. Good morning to you. Counsel, you may at this time, sir.
Okay, my name is John Finn. I'm representing a John Cozy, the defendant, and my P number is 33678.
All right, thank you, counsel, and good morning to you as well, sir. And I know that let me just correct something. 1 second here. seeing some stuff that does not belong in this file. That's. All right, so you've got the matter set for a motion for the summary disposition motion. And it looks like this is a plaintiff's motion. And I believe that you're arguing by way of your motion that there's no genuine issue of material fact, that this has to do with a promissory note, et cetera. Go right ahead, plaintiff, and let's hear what you want to tell me.
Your Honor, actually, your clerk allowed opposing counsel and I to speak prior to the hearing starting. And we would request a continuance of this motion if possible for 30 days. Opposing counsel hasn't had a chance to speak to his client in the last week or so. And we think that possibly a conditional dismissal could be entered so we can come to an agreement without a need for a judgment.
That would be true, Your Honor. I've been trying to get a hold of Mr. Cozy for about a week, and I have no idea where he's at. And he's not here this morning, and he was aware of this hearing date. And maybe he's in the hospital or something like that. I have no idea. But I think that Mr. Cozy understood that we had to come up with some kind of money here, and I need to talk to him. And so I agree. I think that a 30-day continuance would be in order here, Your Honor.
All right, makes sense to me, and thank you for taking the opportunity to speak with each other to kind of go over what the circumstances are. Given the circumstances here, I will find good cause to grant the adjournment of the hearing on the motion. I'll set it over for 30 days with a return date of
July 27th.
what is that?
27th,
June?
July. Oh, you said
30 days.
30 days. I'm sorry. June the. Go right. It was 29. The 29.
June 29. 2022, and that's going to be at 9:45 a.m.
Very good, Your Honor. Thank you.
All right, thank you, and good day to the two of you.
All
Thank you, Your
right.
Honor. Thank you, Mr.
Thank
Finn.
you.
The court now calls case number 21-166-337. This is Citibank versus Anthony Williams. The matter is before the court set on for a pretrial conference date on today's date. And I also see a motion for a summary disposition filed in this matter on April the 7th of 2022. Your appearance for the plaintiff Citibank?
Jennifer Dillo, P69855, appearing on behalf of the plaintiff.
Thank you, Mr. Dillo. Good morning again to you. And do I have Mr. Anthony Williams on this Zoom, please?
Yes, Your Honor.
All right, thank you, Mr. Williams, and good morning to you, sir.
Good morning to you, Your Honor. Good morning to you, Your Honor.
Yes, sir, thank you. Did you receive a copy of that motion for summary disposition in this matter?
Yes, I did receive it. But by the time I got it, I just decided to go ahead and wait for the conference for the day, because by the time I got it back to him, it would have been too late.
All right, got you. So they're moving and asking the court to enter judgment for the plaintiff in this matter, where they're indicating that there's not a genuine issue of fact, and that they're entitled to judgment. There's not really a real dispute as to the claim in this case. You understand that's the nature of the motion?
The only thing I was trying to do before we had the trial today was to try to see if I can work out, paying them less, a little bit less of what they're asking for, because the original balance was like $2,500, but now it's all the way up to over like $3,400.
Right. I believe now the last
Talk
time
to
you were
this
here,
originally my.
did you have this the last time you were here with the other side, Mr. You guys talk about that?
Yeah, we talked about it. He came up with an offer, but I told him, I said, well, would have a problem the balance that they came up with, because like I said, originally I had my account with a debt consolidation people. So I was trying to make the payments and stuff with it. But when the COVID came, that's when I got into financial problems and everything. I couldn't do it.
All right, Madam Counsel, tell me what's going on here, man.
Yes, Your Honor. The defendant is using a debt resolution company. The last conversation we had with them, the defendant, we made offers. I think they were the same offers we gave the defendant at the last hearing. Those offers are the same today. So if the defendant is unable to do either of those options, we'd ask the court to hear the motion.
Yeah, basically, the situation is that either if you believe that you have some financial responsibility here, you would want to see if you could take the offer if it's something better than what the claim is, because now there's a motion for summary disposition that says that the parties don't really agree whether there's money that's owed, and that the plaintiff should be entitled to a judgment based upon the fact that there's not really a dispute here. You can negotiate for something of a lower amount, but if both parties don't agree, then you can't go any further once you reach the end of negotiations. So whatever you guys talked about, the plaintiff says that they're still willing to go forward with that plan, with that scenario. But if not, they're saying they're asking that the judge go ahead and rule on the motion. You understand that, Mr. Williams?
Yes, I do. Yeah, because the original offer they made me to pay $2,400 up a lump sum, but I'm not able to I wasn't able to come up with that lump sum with that, but I'm still willing to pay monthly like they were talking about, but with less of the interest that they added on to it.
All right, were you offered a lesser balance for with a partial payment?
No, I had to make the whole payment of $2,400 in one lump sum.
Yeah, but
yeah.
So what I'm getting at is that whatever your agreement is, or whatever they've offered to you, either you agree with it or disagree with it.
I wasn't able to. When I talked to him, I told him I wasn't able to give them that lump sum, and then even when it was with the my debt consolidation company, that's what they came to me with that one too. So I said I wasn't able to pay that type of amount of money right now in one lump sum, but I'm willing to pay monthly payments, provided I'm just saying trying to see if they could lower it a little bit, not that 2,400, but a little bit lower than the 3,400 that they're talking about. Because the original balance was like $2,500.
Yeah, but that was years ago now. So you're dealing with something. You're dealing with other issues that have come up because of that. All right, our counsel, is there any room to lower some of the balance, even without there being a lump sum, with there being partial payments? I could send you guys to a breakout room and talk about that, but if there's no room for that, then I guess I'd have to rule on the motion. But then, how much are you willing to pay a month, sir?
Well, I could pay the $100 a month. I mean, for right now, as of right now, I can.
Now, counsel.
Yes, Your Honor. We've stated already that the numbers we gave were our client's final offer. So unfortunately, I don't have authority to do a payment plan and reduce the balance. But if the defendant wants to do the 100 per month payment on the full amount of the judgment that we're requesting as a consent judgment, I can certainly do that.
All right, so those are the offers. Either you have the lump sum to come up with, or they're asking for they're willing to enter into a consent for the full amount with the $100 a month payment. So you have those two options. Otherwise, the court would have to rule on the motion, and the motion is likely to end up basically in the same place. With the consent order, you at least have the right at the end of the consent to have the case dismissed. If you pay it off in the $100 increments at the end of the payments, they will sign a stipulation to dismiss the case. But if you get the judgment entered against you, then the case doesn't get dismissed. The judgment remains out there. You'll get a satisfaction of judgment once it's paid off. But that's a little bit different from having the case completely dismissed.
Well,
All right. So you want me to rule on the motion, or you want to go with the consent agreement?
say that again, Your Honor. I didn't quite hear you.
I said, do you want me to rule on that motion, or you want to enter into the consent agreement?
Yeah, I guess go ahead and end the consent agreement.
All right, that seems to be, under the circumstances, I will say this much, Mr. Williams, that seems to be the most reasonable approach to take. I wish that you could get the amount reduced as well. What I suggest to you is that if along the way, even with this consent agreement being in place, if along the way you come up with a lump sum and you wish to pay it off sooner, you might be able to negotiate to get the amount reduced based upon the fact that you have a lump sum. So let's say you pay for the next 5 months, and then you contact your office and say, I have $2,000, I want to pay it off. You might be able to do that. So that you just have to negotiate that and try to finish it out. But the ideal here is that if you're not able to do that, you would at least have a situation where you can control this with the
Right.
$100.
Right. That's basically why I was thinking anyway, Your Honor. So yeah, that was on my mind, and prior to this.
All right, sir.
Okay.
All right, so I will enter the judgment as a consent judgment. Go ahead and submit it to me for the amounts as set forth in the complaint with the appropriate cost set forth. And I'll allow for monthly payments of $100. The first payment would be made on that would be the 17th of June. June 17th would be your first payment. And you make a payment $100 a month thereafter until the judgment is paid off. Once the judgment is paid off, the plaintiff would submit an order of dismissal to the court, dismissing the case. And again, that would resolve this case. Along the way, if you decide that you want to try to lump sum it out, then you contact their office and see if you can reach an agreement to do so at that point. Understand, sir?
Yeah. Yes.
All right. Well, I'll receive the order upon its submission. Madam Counsel, you have the address already?
Does the court want me to submit it by email?
Yes.
I do not. I know the court gave it. I did not write it down.
No problem. It's the first name is Latifah, LATIFAH .Hunter. And that's at 36 District Court, 36TH, 36 District Court.org.
Thank you, Your Honor.
All right, I wish you well to both of you, and good day to you, sir. And we'll see you soon, hopefully on something better.
Okay. Good day to you too, Your Honor, and have a good holiday weekend.
Likewise. All right, good day. Bye-bye.